Welcome to Looking at Legal Stuff. Today we have 8 hearings in a roller coaster of a case where Dad wants Mom held in contempt for withholding the child and involving him in the court process. He claims she encourages the child to refuse to go to visitation and coaches him to reject his father, including having him write a letter to the court to complain about his dad. Mom says that none of that is true and that their son just hates going to his dad's and that no one will listen to how horrible he's treated by his father. She thinks his residential time should be reduced or supervised because her son is refusing to go, and it's not her fault her son is suffering, and she won't make him go if he doesn't want to. That just scratches the surface of the allegations and shade that these parents claim have happened. Let's see how the judge handles this mess.
All right, Mr. Sorensen, can you hear me?
Yeah.
Okay. Phone seems to be working a lot better and it's much more clear. So I'm ready to hear your comments related to your motion of for contempt.
Your Honor, I'm here today to hold Ms. Fike in contempt and regain my residential schedule with my son. As you can see from the filed statements, what I have filed and asking for. The parenting plan was not obeyed by the mother, and the violations are as follows. Did not follow the residential schedule in Section 8, Paragraph B. I was denied visitation on 6/25, 6/26, and 7/7. Ms. Fike disparaged the parent myself in front of the child, which occurred on 6/25 pickup day, which violates Section 14, Paragraph restrictions in the parenting plan, where she discussed adult issue matters, badmouthed me and my wife, and slandered me, used profanity towards me, refused my visitation, and kicked me off her property in front of our son. She asked the child involved to make decisions or requests involving the residential schedule with which violates Section 14, Paragraph restrictions. Ms. Fike and our son clearly discussed changing the residential plan. Ms. Fike requests our son to discuss and to make a decision on attending visitation where he chose not to. She discussed changing the residential schedule with our child outside of already agreed plans, which violates Section 14, Paragraph restrictions. She encouraged the child it was his choice to change his primary residence and his choice whether or not he attends, which violates Section 14 and the paragraph restrictions. She did not construct a regular and consistent responsiveness and cooperation during refusal of visitation, which also violates the Section 14 with restrictions. Tiffany did not attempt to reach me in any way on June 25th to discuss, resolve, or inform me of any disruptions to the schedule, even after being instructed to do so by LPD. She tells my child he does not have to attend visitation, that she is not going to make him, goes and files a plan for supervised visits, and tells me he should stay with her until the 20th. Then, after being informed of contempt, states she can't physically make him go. That contradicts all her claims and that she is following the parenting plan and keeping him from me. Ms. Fike did not notify me prior to pickup to inform me of Christopher's refusal. She had hours to do so and did not. She also did not discuss any resolutions with me, asked me to get help Christopher to attend, did not ask the police to enforce their help, did not ask me to attend a conversation at pickup time. Instead, she had Christopher contact me, inform me he was not attending visitation 4 hours before visitation was to occur. She had plenty of time to contact me during the 4 hours before pickup time to occur and didn't. I attempted to contact Ms. Fike and she denied both phone calls, which puts our child in decision making. I had no choice but to contact LPD for help. LPD then contacted Ms. Fike when she answered for them, and she was instructed to follow the parenting plan and to make sure my son came home, and was also instructed to contact me. Neither one occurred. Ms. Fike never made contact with me. After being informed by Christopher he was not to attend visitation and speaking with LPD, I attempted to pick Christopher up that evening. I was met at the door with Tiffany trying to facilitate an ambush against me in front of my son and Coach Christopher, not once telling Christopher he is to attend visitation and go with me, or to get in the car, which should have been the only issue we were discussing. Instead, she was allowing my son to tell me he is not attending and he shouldn't have to, with his mother in agreement. That she's not going to make him. Christopher was disrespecting me and defying my wishes to get in the car. She also instructed me to read a letter Christopher wrote to the courts, not to me, but to the courts. I read the first few lines and it was talking ill about me and my wife and tired of having to obey our rules, again placing him in the middle of involving him in court decisions. She wanted to control the narrative and shame and slander me in front of our son. It was in a non-constructive environment, not suitable for any discussion. I ended up being told by Ms. Fike to get off her property and to leave without my son. I tried the following day to get Christopher and was met again with text from Christopher that he is not attending. I tried calling Miss Fike, who did not answer, and received text that she is not going to make him. I tried to regain my visitation on the second week I was to have Christopher. I set up counseling for him to attend and tried to contact Miss Fike that Christopher needs to attend visitation. She did not want to hear anything about it. She refused communication about second visitation to start on 7/7. I did not in any way approach Miss Fike combatively or maliciously. I simply informed her Christopher needs to come home, attend counseling, and offered a non-conflict way to get him home. She ignored my text. The following day, however, she threatened harassment charges on me if I were to continue talking about receiving my son. She told me we needed to wait for court and that Christopher should remain with her until then. I contacted LPD, who tried to get Miss Fike again to follow through with the parenting plan, mentioning multiple times it's in her best interest to do everything possible to follow the parenting plan, and she told them as well she was not going to force Christopher to go. LPD then instructed me to continue with the contempt. She supports any and all alienation of involvement and sees no issue with it at all. Ms. Fike, in the midst of this, used her personal server, be that of her mother, Jill Hall, the grandmother of Christopher, who for the better half of 3 years, it was ordered by the courts she is not be around Christopher until she can attend drug counseling and pass a hair follicle test, since she is a known drug addict and has placed Christopher in danger in the past. A woman who is not allowed around my son should not be allowed on my property or near my family. Jill Hall came to my residence twice, both times relentlessly banging on my door and ringing the doorbell for over 5 minutes at a time. Jill Hall is a very dangerous and unpredictable individual that should not be involved in this situation or around in any form. I told Jill Hall when I retrieved the papers to not come back to my property, where she then screamed, "You've been served." Ms. Fike utilizing her mother in this situation is very concerning and puts our family in danger, which only solidifies malicious intent. The constant problem at hand is Christopher feeling pressured and coached to evade my house. He is discouraged from loving myself or a lifelong bonus mom. Christopher voices this time and time again and asks for help on the issue. Every 2 to 3 years, Tiffany tries to find ways to manipulate the courts and change the schedule, use baseless false accusations to attain that. This case is consistent with the previous ones. Christopher displays the same antics at our house, however, it is handled appropriately. Christopher voices major and concerning issues about his mother's home weekly. So we utilize the school counselor when he has an issue. We set up a meeting there to discuss it. We don't ambush Miss Fike or harass her via text, name call, disrespect, or make Christopher feel he has to choose. We pick a professional setting suitable for all parties involved. Your Honor, Christopher refuses. He does not want to attend his mother's visitation almost every week and voices concerns on Fridays. However, we encourage him to spend time with his mother, tell him he is to attend. We run through problem solving, give him problem solving tips. We do not keep him home from her or make him choose to involve him in the court matters that are trauma causing. We always try to facilitate a constructive in-house resolution without slandering Tiffany or causing Christopher to feel in the middle. I myself initiated and asked the court's last custody case to hire a GAL to help with the ongoing issue. I knew involving a professional who works to find the truth would, and she did. Rhonda Larson did an amazing job. She is also available to call on as she is still on our case. I also have been working with the school counselor and Christopher about this exact problem Christopher has with his mother making him to choose sides, lying about my wife and myself, making false allegations. I also attained an outside counselor outlet for Christopher through the school council to help with these issues at Northwest Psychology. I cannot comprehend how Ms. Fike thinks complete annihilation of our family is a good plan. She feels the need to constantly destroy me, my wife's relationship, and family. She uses Christopher in order to do so, not realizing she's destroying him in the process. Christopher has been forced by his mother to write letters, make false claims, and statements about my family, which I know fills Christopher with guilt and embarrassment, as he states. A time my son should have been spending with myself, attending youth group, Christ for the Court basketball camp, collecting his volunteer hours for high school. We have scheduled on our time, attending his job he acquired, family vacations, 2 of which were canceled due to these circumstances, missing a sister. Instead, he spent a better portion of almost a month away from me with no communication at all, under the impression he is prepared to take his father to court. Stressed, sad, and unequivocally involved in adult matters no child should, my son has never gone 3 days without talking to me or 7 days without seeing me in his entire life. While I've been dedicated to following the instructions of the court and parenting plan, Ms. Fike has been creating an environment of paranoia and fear for Christopher, taking him away from his family and disregarding the instructions set forth by the courts and law enforcement. I'm asking the courts to bring my son home immediately for the lost time to be awarded, where he needs to attend counseling, get back into his schedule he lost, and attend his youth group, prepare for school coming up. He desperately thrives on this schedule that has been robbed. I'd like Ms. Fike held accountable so this situation is to never occur again. Thank you.
Okay, thank you, Mr. Sorensen. All right, Ms. Fike, I'll hear your response in relation to the motion for contempt, please.
Yes. So, like you said, this is my third attempt to change the parenting plan. Well, 3 years ago, my son threatened to run away. He's threatened to run away from his dad's house multiple times due to mental and emotional abuse from his dad and stepmom, and more so physical, as you know, Mariah has pushed Christopher before. The reason why I've put this motion into place, because Sunday, June 25th, we got home from my sister's house. It was my nephew's birthday party. He was to go to his dad's at 8 p.m. At 6 p.m. that night, he comes to me or calls me into his room and says, "Mom, what would happen if I refused to go to my dad's?" Is he muted? What would happen if my mom or if I refused to go to my dad's house? I told them, I'm not sure what would happen, but why don't you want to go to your dad's? Like I said, this was 6 p.m. It was 2 hours before he would have went to his dad's house. I'm talking to him about it, why he doesn't want to go to his dad's. He says the same reason for years. He said he was in the middle of writing a letter to the courts. I did not persuade him. This came out of nowhere, that he refused and wants to write a letter to the courts. Did I submit that letter? I did not submit that letter. He wanted his dad to read it because everything on there pinpoints the majority of what's been going on and how he feels about it. My son is mentally and emotionally abused over there daily. He's never wanted to go to his dad's house. He has blatantly said it every single week, but this is the first time he's actually refused to go. I told him I'm not going to make him, but that he needs to go. I feel like he does. But in the back of my mind, from what's been happening over the years, that nobody's been listening. Like, I feel like this, like I said in my declaration, this is his final cry for help. I'm hoping he wants to talk to you, the judge. He wants his voice heard, not what, because the back and forth saying what Christopher says at his dad's house and what Christopher says here, like somebody else needs to be that middleman. And as of counseling, I didn't hear about him putting him into counseling until, let's say, I didn't get served with his papers till the 4th of July. And that's when I read that he had an appointment at Northwest Psychological, which we both should have been informed on that as well. And then the next day on July 5th, Joseph texted me and said that Christopher will be going to that appointment, that he made this appointment, this and that. Well, I already also made him an appointment at Core Health. He has an appointment on August 1st at 1 p.m. Christopher filled out the intake. Christopher filled out all of the questionnaires as it's his counseling session, and he turned it in. So my question is, why or how did he get that appointment with psychological without talking to Christopher about, or having Christopher fill out the child intake? Because that's what the other courthouse says, it's for him. Since he's over the age of 13, teens have a little bit more rights than parents know of. And I said, okay, that makes more sense. So I read the child and intake form that would have been filled out for psychological. And one of the questions were, for you as a parent, why do you think that your son needs counseling? Well, I'm not sure what they put on that piece of paper, but my son is refusing to go to his dad's house. So whatever they put on that paper is what they're telling you. So my thought is Northwest Psychological already has a different version of what Christopher's really going through, because his dad wrote whatever he did on that paper. The intake that Christopher filled out for Core Health is all of his words, all of his answers, all of everything for Christopher. I didn't even read it. I just took him to turn it in. Like, all that is, I didn't read it because I want people to realize I'm not the one making him do this. I'm not the one bringing court into him. I'm not the one who's bringing any of that up. Christopher is pretty much fed up. And what happened at the airport after his his DC trip with his stepmom, I think that might have been the last straw, because it's just too much. I'm really hoping that somebody's actually going to listen. It's not me holding Christopher away from his dad. It's Christopher refusing to go. As my part, yes, I should force him. I'm not going to physically force my son to go somewhere where he's not safe or doesn't feel safe until somebody else says so, which I feel counseling is going to make that tremendous leap, and or talking to the judge or getting that input, because Christopher is suffering. He's almost 15 years old. We've been going back and forth to court since he was little because of everything Christopher has told me. And everything I've written is what my son tells me. I believe him 100%. 100%. Regardless of what people say that he's embellishing stories to get the parents to believe what they want to believe. That is ridiculous, because he's still refusing to go. With Joe saying that there haven't been any contact, Christopher has a phone. He hasn't even tried to contact his son to even ask him why he doesn't want to go. He still hasn't asked him why. He could have put that effort into talking to his son too, because he has a phone. But regardless, I've never ignored his text messages. All the police says their advice is to go with the parenting plan. And I told them I was doing that as best as I can. 6 p.m. is when Christopher brought that up to me about refusing to go to his dad's. I get a call from LPD by 6:20, because Christopher also says, oh, and I text my dad I wasn't going. I never told him to text his dad. He did that all on his own. 6:20, no, 6, around that time, Joe calls me. I didn't answer because I was in the middle of a discussion with my son, trying to figure out why he doesn't want to go, because he had till 8 p.m. to go. So I'm trying to talk to my son. So then he calls the police and says, I'm not responding. So the police call, and I explained to the officer, yes, that I didn't answer his phone call because I'm in the middle of talking to my son about why he doesn't want to go to his dad's house. So that shouldn't be put on me because I didn't answer his phone call. I'm trying to get down to the bottom of it. And he just, nobody's listening. I don't know. When he came over after, Christopher saying and not going, Joe shows up around 7:55 that evening, demanding Christopher to come out. Christopher sitting on the chair. He would not come out of the house. I'm like, Christopher, you need to get up. Christopher, you need to come talk to your dad. It took my husband telling him, Christopher, you need to get up. Go talk to your dad. He got up, went to the door, did want Christopher to read that, or Joseph to read that letter that he did write. He did admit to the police that he only read the first sentence or two, and nothing was slandering or anything about anybody. He didn't even get to read the letter. And with my mother, who's, yes, been 3 years since she was, 3 years ago, Joe and Mariah brought my mother up in our custody case for some weird reason, because my son and my mom are inseparable, inseparable. My thought is they brought my mom up into my court case because they didn't have anything to go against me. Long story short, Judge Basher ordered for her not to see my son in person. They can still contact, FaceTime, and talk on the phone until she does what she was supposed to do, which I did submit the hair follicle tests and stuff too. I'm hoping to address that at this court date as well. My mother has always been the person who serves for me. That has nothing to do with my malicious intent, because I don't have anybody else willing to go over there because of how they are. And my mom's the only one willing to do it, and I need to serve. And I'm not going to pay $40 for a sheriff to do it, because that's ridiculous. My mom banging on their door 5-10 minutes at a time, that's because you're not answering and she's trying to serve you papers. Long story short, everybody is trying to pinpoint all this on me, when I hope people open their eyes and realize my son is in not a very good place. He's very sad. He's depressed. He wants people to listen. He's tired of nobody hearing his story.
All right, thank you, Ms. Fike. I appreciate your input. What I'd like to do now, I want to hear from each party on the motion to modify and the motion for adequate cause that has been brought by Ms. Fike. So Ms. Fike, if you want to address your motion, then I'll hear from Mr. Sorensen, and then I'll give you a ruling on both motions. Ms. Fike?
Yes. My order on adequate cause. Let me find my paper. Has. With my son refusing visitation at his father's home, he's tired of nobody listening. He's scared. He uses the word scared. He doesn't want to go to his father's house. I feel like either limited time or supervised visitation needs to happen until a counselor or somebody can actually open up their mind to listen to an actual 14-year-old. I don't know.
Okay, any additional input other than the pleadings and then those comments that you made there?
No, I mean, I'm sure there is. I'm just, there's a lot. I'm drawing a blank and I apologize.
Okay, it's okay. I read your pleadings and I read Mr. Sorensen's
you.
pleadings. So, Mr. Sorensen, I'll hear from you on the motion for adequate cause and modification of the parenting plan.
Well, as right now, I am in the middle of trying to seek counsel for that. I have a meeting on the 15th. Is the soonest that I could get in to talk to counseling about, or to an attorney about if I need to acquire an attorney for that or not.
Yeah, the motion is properly noted for today, and we're hearing the motion today.
Okay. And then can I go back as far as the counseling that I have set up for him on the 26th?
You can touch on that briefly. Go ahead.
I did not give an intake. The appointment for the 26th is for Christopher to go there to do the intake. I didn't answer any questions or anything. I just simply made the appointment for him to go to there to do the intake. So I just want to make that clear that I didn't answer any questions for Christopher or spoke for Christopher. I just simply made the appointment for him to go and to do the intake himself.
Thanks. Okay, do you want to address the motion for adequate cause and modification?
As far as the adequate causes, I feel that this has kind of been an ongoing thing, as I stated in my statement for the contempt. I mean, I've hired a GAL. The GAL has you said you've read through it, so you've read what her report. We're kind of running into that same thing to where Christopher is playing both sides.
So just so you're aware, Mr. Sorensen, I did not read all 222 filed documents in the file. I read all applicable and relevant motions related to the two motions today. So I see that Ms. Larson filed the guardian ad litem report back in January of 2020. I have not reviewed that.
Okay. She had found what her findings were is everything that I'm stating, that Christopher was found to have to choose sides over at his mother's house, and that he is involved in adult conversations and in these court matters. I feel like, I mean, that's all we have is Christopher's best interest. And right now, I have a lot of rules. I mean, I hold him accountable, and he gets away with a lot more at his mother's. So it's kind of Disneyland versus somebody that has, I have rules.
Okay. All right. Thank you. Okay. So at the outset, it's, Christopher is, he's at a really interesting age. He's 14 and sounds like he's almost 15 years old. And it's a tough place to be as a teenager. Number one, it's a tough place to be for a teenager caught between two homes with different parenting styles, it sounds like, and different approaches to parenting. So here, the motion is brought by Mr. Sorensen for a motion for contempt related to the June 25th visitation. The parenting plan calls for a 50-50 plan, roughly. Well, it's a 50-50 plan with exchanges on Fridays. It sounds like the parties have kind of modified that a little bit to make it easier on them for whatever reason. So that's the motion. The indication is that Mr. Sorensen indicates that there was that there was a refusal of Christopher to come to the visit. There's an indication by Ms. Fike that Christopher has some thoughts about what's happening, what he wants and what he doesn't want. And there's an indication that there was not a clear push or edict, if you will, or direction from Ms. Fike that he needed to go with his dad. Her focus tended to be more on listening to what he had to say. Dad's focusing to be more on there's a parenting plan and we need to follow that. So these situations are challenging because both parties have a lot to say. And I think that was noted by the variety of pleadings that were filed by the parties. And there's a lot of information that needs to be heard. So the issue is that there's a parenting plan. The parenting plan says it's a 50-50 plan. Life is not static. Children change, parents change, and the court system is kind of slow to change. We're not the most nimble of organizations. And so when there's a change, there's a feeling of immediacy. We need to make a change quickly. Things may have been brewing for some time with Christopher, may have been thinking about some things for a long time, but it kind of came to head on this June 25th date. The difficult part is accommodating that and accommodating the parenting plan. There's kind of a natural tension there. So what needs to happen is that there's a court order. The court order controls. The parties have been unable to come to an agreement themselves, and so they've turned it over to a third party, the court, to resolve and guide the issue. So the court said those parenting plan needs to be followed, and the parents are to make sure that it happens. And 15-year-olds, certainly you can't pick up a 15-year-old or 14-year-old and pick them up and put them in a car. Not going to happen and would be inadvisable. There's other ways to persuade and encourage. And so I will make a finding of contempt. I think there was a clear indication, whether it was stated explicitly, I think it was the implicit message was clear. I'm not forcing you. You don't have to go. I don't think those words were specifically said, but I think the message came across clearly to Christopher that he did not need to go. And it was more important that his father engage with him, listen to him. And the parenting plan indicates that when I looked at that earlier today under paragraph 14, it says the following. I think this is important to note. Where it states, each parent agrees to encourage the child to directly discuss with the parent in question any grievance they may have with that parent. I think that was appropriate. Ms. Fike indicated that Christopher had written a letter and he had wanted to share that with his dad. And it sounded like she encouraged Mr. Sorensen to speak to his son about that issue. It also indicates it's the intent of both parties to encourage a direct child-parent bond of communication. So that's there. So what I'm going to do, I'm going to impose a $100 civil penalty that contempt can be purged by following the parenting plan for 6 months or until there's a change in visitation. So I also think, and both parties recognize this, that Christopher needs some support through counseling. Sounds like both parties are cognizant of that and working towards that end. That's encouraging and good. And both parents can provide input to the counselor for the benefit of the child. So there's 2 counselors. I don't know if I need to rule on which counselor is going to go, who Christopher is going to attend with. A lot of counselors, it's a personality fit, and sometimes it's you meet with one counselor and it's just not a good fit. So I'm going to leave it to the parties to figure out which counselor he goes to, but he needs to be seen by a counselor. He needs to have that outlet. I'm also going to order this because I think both parents here have a lot of information to share, and there's a lot bottled up that's just needs to come out. So I think I'm going to require both Mr. Sorensen and Ms. Fike to engage themselves with the counselor for at least 3 sessions to discuss how your actions contribute to the situation. It's going to be a self-focus, it's self-reflective to better determine how you are contributing to the issue. I'm also going to require, I'm going to appoint a guardian ad litem. So the guardian ad litem can interview and speak with Christopher so his voice can be heard And then both parents can have their opportunity to be heard also. That guardian ad litem's duty is simply that, to address the issue of a 14, almost 15-year-old boy as far as residential schedule. That's the sole focus. And to make clear that Christopher is not allowed to make the decision of where he goes. He's required to go as the parenting plan requires, and he should be disavowed of that false notion. It's gonna be a lot slower than a 14-year-old child wants things to happen. But we're going to get input from the guardian ad litem. He'll have an output with the counselor. Both parents will have opportunity to do some self-reflection under the guidance of a counselor to see how they're contributing to the issue, because it doesn't happen in a vacuum. And sometimes it's hard to see that without the professional help. So that's the contempt motion. As far as the motion to modify and the motion for adequate cause, I'm making a finding that there is not adequate cause at this point. So I'm denying the motion for adequate cause and denying the motion to modify the parenting plan. So with that said, I'll ask the parties if you have any questions or clarifications of the court's ruling.
As far as my lost time of the 2 weeks that I missed out on, is that just chalk that up as?
Yeah, good question. I thought about that, and I think under the current circumstances, I'm going to let that ride. I'm not going to order makeup time. I am requiring that the parenting plan pick up this Friday at the Friday or whatever. It sounds like it was Sunday, maybe what the parties had kind of agreed on. But the parenting plan, if the parties can't agree, it'll be Friday at 5 p.m. That's when the exchange needs to occur. If the parties had been doing a different schedule, you're free to do that, but it has to happen this weekend. No. The exchange needs to occur.
Okay.
Ms. Fike, do you have any questions or points of clarification?
No, not at this time. Well, actually, when will we hear about the guardian ad litem?
Yeah, thanks. So I'm going to ask the guardian ad litem to do an accelerated review with a review in 30 days is my hope. And for guardian ad litem, that's a pretty quick turnaround time, and we'll have a hearing in roughly 30 days. And so let's go ahead and look at the calendar now and see what we have. Yep. Yeah, thank you. Let me take a look at the calendar. 1, 2, 3. Let me ask the parties, as far as your schedule on August 24th, how do your schedules look on August 24th? That's a Thursday at 9 a.m.
I'm recovering from back surgery, so I'm pretty free.
Okay, Ms. Fike.
That's fine with me as well.
Okay, we'll set it for that day. And then the guardian ad litem, it was mentioned Ms. Larson, and do the parties know if she was formally discharged from the case?
He told
No.
us that this was her last case and that she was retiring, so I have no idea.
She was never discharged, but I don't believe that she is doing child ad litem work still. But
Right.
she is still technically, I think, when I reached out to her, she said that she is still on the case.
Yeah, I don't think she's been formally discharged, and I think she's no longer on the guardian ad litem, what we call the registry, so she's not accepting new cases. So Madam Clerk here has a list of the next 3 available guardian ad litems. Each party has the opportunity to strike or get rid of one of the guardian ad litem that have been presented. So I'll give you that list, and then each of you can tell me what your thoughts are as far as what your preferences are as far as striking. Oh, the review, 24th of August.
Next 3 names are Twyla Corey,
Okay, Twyla Corey,
Keith Lawrence,
and
Heather Kale.
And Heather, last name?
Kale is Kahl.
And Heather Kale. So those are the 3 proposed. So with Ms. Fike, you're the petitioner. Do you want to strike any one of those 3?
I mean, no, maybe the second one.
Keith Lawrence?
Yeah.
Okay, we'll strike him. And then Mr. Sorensen, any of the remaining 2, Twyla Corey or Heather Kale?
I don't know any of these, so no, not really.
Yeah, it's kind of operating in a vacuum. It's difficult. So generally, it's a hierarchical order in which they're listed. So Twyla Corey is first, and then Mr. Lawrence was stricken, then Ms. Call was listed. So I'll appoint Twyla Corey as the guardian ad litem. She will be reaching out to the parties, and it's important that the parties respond to her promptly. I think it's that there's a brief packet that she'll have you fill out. But the sooner you can get in touch with her, the better, so we can move this along. And then as far as the payment, let me ask, was Ms. Corey, was she paid by the court, or was she paid by the parties?
Londa, I think I had to pay. And
We
then I
each paid
believe,
half.
You each paid half? Okay.
but I believe that hers was waived.
No, it was not,
Okay.
but regardless.
Okay. So what I'll do, it'll be a 50-50 split as far as the payment. And then, so she'll get that order. She'll be in contact with both parties, and you'll have opportunity to chime in, and Christopher will have opportunity to chime in. And I will draft up an order memorializing today's rulings on the motions, and get that out to the parties. Do you both have access to Odyssey?
Yeah.
I think so, yeah.
Okay, that's where you can access the case file and look at all the pleadings that have been filed. So I'll file it there, and the parties are welcome to look in there and take a look of the order.
And can you spell Twyla's name first and
Yeah.
last, please?
Yeah. Yeah, Twyla is Twylla, and Corey last name is Corrie.
Perfect, thank you.
Let me check with the parties before we end today's session. Mr. Sorensen, do you have any final items?
I don't believe so, Your Honor.
Okay, Ms. Fike, any final items?
No.
Okay. All right. I appreciate both parties' time and input. And that will conclude today's hearing. And then we'll see everybody on August 24th at 9 a.m. for the guardian ad litem report related to a residential schedule. Okay. All right. Thank you.
Thank you.
Okay. That marks.
All right. I think that takes us to the Hall and Sorensen matter. This is 19-300-39308. All right. And Ms. Corey, are you on that matter?
I am.
All right. Very good. Okay. So let's see. I have a contempt filed by Mr. Sorensen. So I'm going to address the I'm going to have you go ahead and make argument regarding the contempt, sir, and then we'll talk about the adequate cause next. So go ahead. I have had an opportunity to read all the documents in this case. I appreciate that you both file documents and materials. Sir, why don't you tell me what you want me to know about the contempt?
The parenting plan, Section 8, Part B has been broken since she's withholding our child, rejecting visitation after Christopher fled from my house to Miss Fike's sisters during our parenting time. She is in violation of the week on, week off schedule. She refused to bring him home to me or comply with police officers to bring him to me, or to cooperate as a parent in any way to communicate, discuss our current situation, as you can see from the text that I had filed. Section 14 under restrictions was also violated, where she discussed the residential schedule with our son outside of already agreed upon parenting plan. She discouraged our son to not attend and led him to believe it should be his choice. He came under the impression his mother hates the ruling set forth by Judge Evans, and that she is not the one making him come to my house, that it was a stranger making these choices for him. It is my understanding that Section 14 exists because Christopher benefits if he is under the impression that both parents are on the same page with respect to the current plan. He should be under the impression that the courts are looking out for what is best for him. It would benefit transition day to see both parents be supportive of one another in front of him. The opposite happened. By not setting a positive example of the transition, I believe it set stage for our son to flee. Our child was not in any way in danger, harmed, neglected, or suffering. After our son sneaking out, she had no legal right to keep him away from me. Christopher's transition to my house was well planned, including therapy sessions, church, a basketball camp, and reunification counseling. He had everything in place for a smooth transition, but it was stolen from him.
So when is the last time you had your son in your care?
The 22nd,
of June?
August.
Okay. Wait, hold on. So it's August now. So,
Yeah, June. Sorry, I'm
Okay.
sorry.
okay. So June 22nd, and you haven't had your son in your care since then?
No.
Okay. Have you had phone contact with him since then?
I've tried to reach out to him via text, and I haven't received anything from him back.
Okay. Thank you. So I'm going to handle these one at a time. I might make my decision all at the end, but I want to kind of do one operation at a time. Ms. Corey, tell me about your involvement in this case. So I see old orders in this case, or old GAL reports, but I don't see a current, and I don't see an order appointing you. So tell me how you entered the case.
So I was appointed, I believe about 3 weeks ago. I
Okay.
believe it was by Judge Evans, and it's been kind of a comedy of errors. I have not yet gotten an order appointing.
Okay.
But because there was a very quick turnaround, and Judge Evans was looking for an initial review next week in this case, I went ahead and got started and sent intakes out to the parties. They filled them out. I've interviewed both of the parties so far, but because I don't have that order appointing yet, I'm just kind of stuck at this point.
Okay. Very good. That makes perfect sense to me. So I appreciate that. Have you been able to talk with the child of the case?
Not yet. Because it's outside of the school year, and I like to speak with the children in a more neutral place than one of the homes. I have been, I believe I have a place to do that secured, so I'll be setting that up soon.
Okay, very good. I appreciate that. All right, Ms. Hall, what would you like to say about the contempt?
I am Miss Fike. I've been married over a year now. Sorry about the paperwork, but my last name is Fike.
Okay, so when you name yourself on the screen, go ahead and name yourself Ms. Fike instead of Ms. Hall, and that's certainly helpful to the court, giving you the correct name.
Okay, I didn't see my name on here at all. Okay, so on June 25th, my son refused to go to his father's house due to mental and emotional issues that we've been going on for years, as of the other court papers. We had a court date July 20th. That was when Miss Corey was appointed to us to figure out why he refused to go to his house and figure out what the issues really are. Judge Evans said he appointed Twyla for Christopher's voice. He ordered Christopher to go to his dad's July 21st, that next day on Friday. So he's seen his son the end of July, not June. Christopher went to his dad's. Well, his dad showed up. Christopher took off down the street. His dad went after him. They ended up leaving together after they talked, just for me to get a call the next morning that he ran away from his dad's house. Talking to the cops, they never told me to bring him back. They said they understood and to keep him safe. So I don't know what he's meaning, what the cops said to him, but what the conversations with the cops with me were totally different. And they were aware of the court. They're aware of the guardian ad litem. So for me to try to keep my son safe and why he's refusing and running away from his father's house, I want those things to be addressed. I'm not withholding Christopher. I'm not keeping him from his dad. If he goes there again, what if he runs away again? So I'm trying to think of down the line. No, I'm not withholding him at all. Christopher refused. Christopher ran away from his father's house. And I feel like, knowing all the stuff that's been going on for years, and I can't force him to go, especially he's 6'2". I'm not going to physically force my child to go. Yes, we need to figure out why he's not wanting to go and people to listen, but I am definitely not withholding my son from his father. That's the whole reason why Miss Corey is here, to, I can't wait for her to talk to him.
So does your son have a cell phone?
He does.
And he has it currently?
Yes.
Okay. Has he been in the last month visiting with friends?
Yes.
Going places?
Mostly my sisters, because I work, and him and his cousin Ashton are best friends. This whole summer, he's been to 4 different friends' houses on my time. 4 times this whole entire summer. So yes, he has.
What school district are you in?
He was starting his freshman year this year.
All right. Thank
He
you.
had his first counseling appointment with Core Health on August 1st. He had his second one on the 15th, just 2 days ago, with Core Health as well. So he is in
Did you
counseling.
provide the father with the information regarding the dates and times of the appointments?
No, but they were verbally said in court what time they were.
Did you provide the father with the name of the counselor?
No, because I just found out the name of the counselor just last week because we did the intake with a lady named Linda, and I just met Hannah, which her name is Hannah from Core Health. I don't know her last name. On the 15th is when we met her.
Does your child have a diagnosis?
Not yet, no. They're setting up another counseling for this afternoon and hopefully next week.
How many times have you taken the child in the car and taken him to his father's house since that last July visit?
He hasn't been to his father's house.
Right. I'm asking if you put the child in the car and drove him over to dad's house.
No, I have not.
Have you dialed up dad on the phone, handed the phone to child and said, you need to talk to dad?
No.
All right. We're also before the court on the issue of adequate cause. So ma'am, you filed those documents asking for adequate cause to modify the parenting plan. What would you like me to know about that?
The reason why I want to modify is because of his refusal and not wanting to go. I want him to see his father. I want him to be able to have that relationship with him, but there's also something going on there that we need to figure out.
Okay. Sir, what would you like me to know about adequate cause?
Well, I mean, this has already been proven that there was no adequate cause by Mr. Evans. I don't really, as of right now, I mean, other than since he's been in Miss Fike's care for the last few months, I've been receiving countless. He's been sneaking out, running. He ran away from my house. He's cut himself off of all of his encouraging friends and relatives. That's where I'm at.
I see
Yeah,
that
yeah,
you-
appointed Twyla to figure out what's going on. So with that being said, I feel like Judge Evans, excuse me, in a way, not believed, but believed there's something going on, that he said guardian ad litem to be Christopher's voice. So I don't understand. We get 2 different aspects of what.
When was that hearing held?
July 20th was our last court date, with him refusing to go to his dad's.
I'm just looking for the clerk's minutes. Okay, here we go. So did the court just put it on today for review? Because it sounds like the court previously found contempt. So the court found contempt on on July 20th. The court found contempt, denied adequate cause, will sign the order, and court appoints guardian ad litem. Initial review next week. So this is your second contempt, sir?
Yes, ma'am.
Okay, so I was just clarifying because it looked like when I initially prepped for today, it looked like because there wasn't, I didn't have that note as far as the adequate cause being decided. I did see the second contempt. Okay, so then we're just on for those 2 things. And then Ms. Corey, what I'm going to do today before I leave is to issue an order for you so that you will have that today. And I will ask my clerk to send that or my JA to send that out so that you get a copy of it and can start executing on it. Did the court set financial obligations or no? To your knowledge?
I do not recall. I believe it was private pay.
Okay, That's fine. I'm going to do private pay and I'm just going to make the parties 50-50 at this point for your services. We'll keep it on next week for that review. And then give me just one moment. So that's already been done. Okay. And so, sir, I just want to clarify, when is the last time that you saw your son? Was so July?
Yes, ma'am. When he was ordered to come to my house for the Friday, which he didn't want to give me any lost time or anything, but we were supposed to resume the regular parenting plan of week on, week off. And then he fled my house that next morning, and then I haven't seen him since.
Just one moment.
Other than that short little window that I did receive him, it's been nearly 60 days since I've had my son. Which is, I mean, I've never been more than a week.
Yep, give me just one minute. And ma'am, it's your testimony that I saw there was a statement from the child, and it's your testimony that was the child's statement that you asked him to write.
Absolutely not. No. On June 25th, Christopher was supposed to go to his dad's at 8 p.m. that night, and he calls me in there a little before 6. Says, Mom, what would happen if I refuse to go to my dad's? I don't want to go. I'm tired of everything. So we talked to him about it and what would happen. And he said, I'm also writing a letter. He was in the middle of typing that said letter. And he said he wants me to read it when he's done writing it. So no, I did not make him write. I didn't tell him to write. There was a surprise that he was not necessarily a surprise, because he's never wanted to go to his dad's, but he's always went. He's never refused. He's never ran away. I feel like there's something going on because nobody's listening. There's something going on over there of why he refused and
All
why
right.
he's moving
Thank
away.
you. You've answered my question. All right, folks. I appreciate everyone being here today. I appreciate Ms. Corey being here today. I am going to find contempt. I'm going to enter a civil sanction of $1,000. I'm finding that the mother is able to follow the court orders, but is not willing, that you are intentionally defying the court's orders. I'm also making a separate finding that the mother is directly involving the child in the court process, and that you are encouraging the child to disobey and making no effort to follow the court's orders. Here's the reality. Nope. This is where I talk. I've given everyone a chance to talk, and I've listened. When I read the court file, here's my take. If I was making a decision on adequate cause today, I'd make that finding and I would transfer full custody to father. That's your risk, ma'am. What you're doing right now, you are fully aware of what you're doing. You are deciding that you are going to disobey the court order. You're not encouraging your kid to go. You're allowing your child to believe he has some kind of say. He does not. This is a parental decision. And if the two of you can't make that decision, it's the court's decision on where your kid's going to live. Your child is more important than ownership. And what I see in this case file is ownership, is somebody wanting to possess that child, own that child, but not parent that child. And that is a huge concern for the court. When I see these nice text messages between child and stepmom, and then you telling kid, you don't even have to answer her. You don't have to go to that sports game. That's ridiculous. When you tell a child, especially a young teenager, you don't have to respect that adult. You know what that translates to? I don't have to respect mom. I don't have to respect dad. I don't have to respect my teachers. I don't have to respect the court. I can blow all of that on all those people off. So when you think that you're just telling, oh, you can disrespect kind of stepmom, that's not what's happening. You're telling that child he can disrespect everyone. That is terrible for that child. You have 4 years left with this young man before he is launching off to adulthood, and you are setting him on a course for disaster. because you are setting him up to think that he can just disobey everyone. And that is not how school works. It's not how the world works. And that's going to be a harsh reality for him. When you do those types of things, it is so damaging. And especially when what I see on the other side is folks being loving and caring. Look, teenagers are hard. They are hard work. They are not easy. Sometimes they are just going to be disobedient and annoying and frustrating. But that's where you as parents come in, and you need to step up and say, you have to go to your dad's. It's your dad's time. You're going. And what you're doing right now is he's on his phone. He's playing his little games. He's going to his friends' houses. That all sounds like he gets to do what he wants. And you're teaching him that instead of follow the court order. It's at the end of the day, it's you that are going to pay the penalty for this, not the child. It's you that risks losing all custody of your child. I honestly had notes on whether or not there needed to be a pause in any contact with you, ma'am, before, and the child needed to be with dad and no contact with you for a period of time. That's how serious I take these orders. That's how serious the court takes orders as far as parenting time. So this idea that kid gets to be on his phone, dinking around, watching TV, eating snacks, all while you are fully aware he's disobeying the court order and you're disobeying the court order, that is not acceptable. And you need to think long and hard about your course of action, because you're going down a course of action that I don't think you're going to like the outcome. So at this point, I'm signing the contempt. Ma'am, I highly recommend that you ensure child goes on his visit with his dad. And it's not a visit. Child needs to go to dad for his dad's residential time. Dad is an equal parent here. And everyone needs to realize that and get on board really quickly. Because at this point, the court hasn't found adequate cause, but I think the court essentially is reserving that issue, and it can go the other way. The court can find adequate cause and award father full custody. So that is the risk here. So I encourage everyone here to really quickly get on board with getting child to both houses as ordered. There should be no further deviations. Child starts school in a week and a half. The idea that we're going to play this game as child starting his high school career is ridiculous. Everyone needs to get on board with what the child needs. And stop sort of playing these games. Encourage relationships with both sides. Stop alienating father and father's family. That is not helpful to that child. You should be thankful and grateful for every adult that wants to be, every positive adult that wants to be involved in your child's life, instead of trying to encourage your kid to blow them off and ruin that relationship. That's not healthy. It's damaging. So, I'm making finding of contempt. I'm setting the matter over for 1 week. Everyone needs to communicate with Ms. Corey anytime that any documents she asks for, any materials she asks for, any access she asks for to anyone. Everyone needs to be Johnny on the spot with that. And then Ms. Corey, I don't think the court's expecting a written report from you. I think an oral report will be just fine, given the sort of limited nature of your ability to chat with everybody and the court not getting that order entered.
Thank you.
All right. So I've made myself very clear. It is my expectation that that young man will be exercising his regular time per the court order. Best of luck to you all. We'll see you here next week. All right. That's going to take us to Hall and Sorensen. And I did see Ms. Corey on the line. There you are. Welcome. And then do I have Ms. Tiffany Hall? All right. Oh, Tiffany Fike. That's right. Thank you. And Mr. Sorensen.
Yes.
Perfect. I see you there. All right. Ms. Corey, go ahead.
Well, I have had the opportunity thus far to meet with both of the parents and the child. I really have no recommendations beyond the original parenting plan at this point. I believe we should move forward with that in place as it is, and go from there.
Thank you, Ms. Corey. I appreciate your report. All right. Next, I'm going to turn the time to you, Ms. Fike. At this point, the Guardian Alliance recommendation is to maintain the current parenting plan, at least until she can further her investigation. Would you like to speak to that, Ms. Fike?
Yeah, I mean, that's great that she wants to keep it the same and wants to further this investigation. I feel like that's a great idea for her to continue her investigation.
Okay, thank you. Mr. Sorensen, go ahead.
I feel the same. The only other thing that I would like to request is maybe if we could apport a third party communication outlet, like My Family Wizard or something like that. Me and Ms. Fike just can't seem to communicate very well, even via text messages. So I think that would be a good outlet for us to utilize.
All right. Ms. Fike, any opinion on using Our Family Wizard or a similar parenting app?
I've never had issues with text messages other than him not responding to my text messages. So, I mean, I feel like text messages as well as the Wizard app, I think it'll be the exact same. So, I mean, I'm not sure.
Give me just one moment. Mr. Sorensen, has the child began following the current parenting plan?
Yes, we had a really good week this week.
Good. All right. Thanks, folks. I'm glad to hear parenting plan's getting back on track, and the guardian ad litem is getting online. Thank you, Ms. Corey, for being so quick. I know that was a very, very fast turnaround, so I appreciate you making that effort. Here's what I'm going to order today. So I'm just going to order that the current parenting plan be maintained, that the GAL investigation will continue. The parents, I do want you to use Our Family Wizard. You'll both need to log on today. Just if you Google Our Family Wizard, you'll be able to find it. You both need to pay your own fee for that. The fee is pretty minimal. It does do some sort of housekeeping functions that can be useful to both of you, and it's a good way of sort of managing those communications. You'll each pay your own fee for that service, but again, it's fairly minimal. Ms. Corey, I did set, I believe, a review in that guardian ad litem order. Let me just double check. Yes. Oh, no, it says to be determined. So I did not set one. So let's do that today. Ms. Corey, when are you looking to be able to complete your investigation?
Probably end of October, early November.
Okay.
And I also do need to address payment today.
Okay. Let's set a date and then we'll address payments. All right. I'm going to say, let's have your report. Let's have it ideally no later than November 7th with a review on November 14th. Oh, I'm sorry, not 14th. I'm going to put this the 16th. Is the Thursday. All right, so we'll be back here and all parties will need to be back here on November 16th at 9 a.m. Again, still via Zoom, so you'll just need to appear the same way you got to today. And then Ms. Corey, tell me about payment.
No payment received as of yet from either party. Both have indicated that it's a hardship for them.
Okay, so sir, let's address that with you first. Are you currently employed?
I'm currently on FMLA. I had back surgery the end of June, so I've been trying to recover from back surgery. I should be getting back to work here hopefully in the next couple weeks or so, but it's been kind of rough off of FMLA.
Okay, and Ms. Fike, as to payment of the guardian ad litem.
I told Miss Corey that because I was told I can get a waiver for her fees because I cannot afford it at all. I had a medical emergency. I was out for a month and a half as well. And I even called the clerk's office because I couldn't find that waiver fee, and they even helped me look. The administration at the clerk's office helped me look for that. And they told me to address that in court, that we can't find the waiver fee for her fees.
Okay, well, I just appointed her last week, so I don't think anything's been submitted for that. If there was previous waivers in the file for like a prior GAL or a prior fee, that wouldn't necessarily translate to the waiver for Ms. Corey's fees. How long ago was your medical emergency?
It was all through June, July.
Okay, are you working?
I just got back to work, yes.
Okay, how much do you make per hour?
20.
Here's what I'm going to do. I'm going to transfer this to county pay. So I am going to have the county pay it, but I am going to make that, Ms. Corey, to be reviewed because it sounds like both parties had some sort of issues that happened pretty recently, but that those issues would likely be resolved by the time we get to the hearing in November. So what that means, folks, is that the county is essentially going to pay Ms. Corey up front. The expectation, though, is that you may need to reimburse or pay additional funds to Ms. Corey at the end. So don't assume that that means that you're, sort of don't have any obligation going forward. It's just that the court's going to allow payment of Ms. Corey directly from the court initially, and we're going to review that in November. Does that make sense to you, Mr. Sorensen?
Yes.
And to you, Ms. Fike?
Yes, ma'am.
All right, very good. So with that, anything further on this case, Ms. Corey?
I don't believe so.
All right, anything for any other questions from you, Ms. Fike?
No, I don't have any more questions.
All right, to you, Mr. Sorensen?
No.
All right, very good. Thank you both. And thank you, Ms. Corey. Go
I'm
ahead.
so sorry. I do have a question. 2 court dates ago, I submitted my mother's hair follicle test. My son hasn't seen her in almost 3 years. And Judge Basher's the one who put that in to where she needed to do that for my son to see her. And I wasn't able to say at either court dates to bring it up again, but it was filed. Can my son see his grandmother?
That's not before me today. If you want to address that, you have to file a motion. So that's not before me today. You can file a motion and then the court can address that.
Okay, so is it just any motion? Because I was told just to submit the paperwork for my court date, and that's what I did, and it's never been addressed. I didn't know what motion to file.
I can't give you legal advice because I'm sitting as a neutral decision maker. So I can't give either party advice on what to do or what to file. So I invite folks to speak to legal aid. You can hire an attorney even just for a consult to get advice. You can look online. There's lots of options for you, but I can't direct you specifically on what to do.
Okay.
Okay, appreciate that. All right, with that, I am going to sign an order that just reflects my rulings today. And makes it clear for the next judicial officer when we get here in November to sort of have a good idea on what's happening. All right. Thank you both. That concludes this matter.
Okay. Sounds like it might be on our end. All right. Mr. Sorensen, can you hear me?
Yes, sir.
And I see a Tiffany Fike. Is that formerly Tiffany Hall?
Yeah, it's Tiffany Fike.
Okay. And you can hear me as well?
Yes, sir.
Yeah. Pardon me. I forgot to mute my phone when I came in. Okay. All right, Mr. Sorensen, this is on your motion. Anything you wish to say? I've read what you've submitted.
Yeah, Tiffany violated the order signed by Honorable Commissioner Baldwin at our most recent hearing. Commissioner ordered both Tiffany and me to use our family wizard as a means of communication from now on. After court, she ordered both of us to contact our family wizard and pay our portion of the order. I complied immediately. Tiffany did not comply with the order and later refused. This is Tiffany's 3rd contempt since July. She continues to disregard the court orders. As you can see in her most recent declaration, she blatantly disregards the orders of the court, criticizes and devalues Commissioner Baldwin's qualifications and judgment, complains about her present guardian ad litem, Twyla Corey, tells the court exactly what she will and won't abide by. So you can imagine how she addresses me behind closed doors, which is why the need for the third-party communication outlet is vital in making CRISPR the priority for the few years we have left. We are all doing our best for Christopher, our current GAL, Twyla, the judges and commissioners who have assisted us in the case. We are all working diligently to comply with the court orders to ensure fairness and do what is best for Christopher. I am doing everything in my power and have complied with every order placed and corralled in every way possible. Does not make sense for this case when only one parent is actively working to make Christopher a priority. Tiffany seems to be escalating and creating a worst possible scenarios to impact her son. I just request that the courts help me cement a preventative measure and continuing contempt.
Ms. Fike, is there anything you wish to say?
Yes. My son is my first priority. My first contempt, my son refused to go to his father's. I tried to get court right away. Of course, court dates are always 2 to 3 weeks out. I was held in contempt because my son refused to go to his father's. He was ordered to go. He ran away from his father's house. So we did more paperwork, went back to court. I was held in contempt because, again, they were thinking I was withholding my son when he's the one refusing and ran away from his father's. This last contempt or court date, she asked my opinion on the My Family Wizard app. I declined it. I said, there's no need for an app when we've text messaged this. My son's almost 15. We've been using our phone communication for almost 15 years, and it's never been a problem until he addressed it last court date that it is a problem, and it's not. And I can't afford to pay the guardian ad litem, and they already know that. And I can't pay to download an app on my phone that does something that I already pay for. So I don't feel like I should be held in contempt because for not downloading an app because we communicate just fine during text messages.
Well, from looking at the text messages, it's pretty clear that's not the case.
I don't understand that.
The text messages look pretty, they escalate quickly and a lot of people get obnoxious, don't you think?
I believe that's what I put in my declaration, that he was the combative one, and I try to communicate, and he's always rude to me.
Okay, anything else you want to tell me?
No, I think that's it.
All right, Mr. Sorensen, anything you want to respond to?
As far as the payment, it's $99 for a year subscription to the app.
All right, so Ms. Fike, this is real simple. There's an order that says you're to both use the Family Wizard. That's not a suggestion. It's not aspirational. It's a court order. And you have to follow it or you're going to be in contempt. That means when you're in contempt, you either pay money or you do jail time or there's some other sanction. So here's what we're going to do. You're going to get that Our Family Wizard and you're going to get it immediately. I'm going to continue this matter for 1 week. Next Thursday, that'll be the 28th at 9 o'clock. If you've got the Family Wizard, we'll talk about what kind of fine, if any, is going to be imposed because of your failure to get it so far. If you don't have it, the options are a lot more serious. Is there any part of that you don't understand?
No.
That will be all.
Thank you.
That will.
Thanks.
Computer program is running very slow. So, ma'am, I put this over today to confirm that you had signed up for the Family Wizard. Has that happened?
Yes, it has.
And can you confirm that, Mr. Sorensen?
Yes, she signed up for it on Tuesday.
All right, thank you. So, ma'am, I want to make sure you understand if there are violations of the order down the road, it's going to cost you money or worse. So those orders are not suggestions. You understand that?
Yes, I do.
Okay, then we will leave it there.
Tiffany Hall and Joseph Sorensen. I'd like to call that next. Tiffany Hall, are you on the line today?
I'm here.
All right, welcome, Ms. Hall. And Joseph Sorensen, are you here today?
Yes, Your Honor.
Okay, welcome. All right, so we're on today for a pre-trial for a trial of on a modification of a parenting plan that's set for the week of January 22nd this year. And we also have a readiness hearing on the 16th of January at 11:30 that will determine this precise date. during the week of the 22nd that the trial will be heard. So as far as pretrial, pretrial generally is a time in which it's a time of preparation to make sure that everything is ready for the trial and that all information has been exchanged between the parties, documents, witnesses, contact information of witnesses has been provided. So let me just touch base with the parties. Ms. Hall, do you have an idea of what individuals you may call as witnesses during the trial?
I do. I have about 4.
Okay. And have you provided those names and the phone number to Mr. Sorensen?
No, I have not.
Okay.
I thought that's what we do here is voice it to you guys. So I wasn't sure how to. Okay.
Sure. I mean, you could do it one of two ways. Doing it verbally here is helpful. But sometimes some things are lost in the translation, if you will, and that's why the written word sometimes it works a little bit better. So those 4 individuals, who are those 4 individuals?
It'd be my husband, Joseph Fike.
Okay.
My father-in-law, Ed Fike.
Okay.
My sister, Haley Gomez.
Haley Gomez. Okay.
Gomez. And my mother, Jill Hall.
Jill Hall. All right. Mr. Sorensen, any questions related to those witnesses or potential witnesses?
No, Your Honor.
Okay. And I'll ask the same question to you, Mr. Sorensen. Do you have, who are the individuals who may be potential witnesses at trial?
I'm not calling on any witnesses.
Okay. So you just yourself?
Yes, sir.
Okay. All right. Then let me ask the parties, the main contention or the issue to be solved at trial, Ms. Fike, can you tell me what that is?
I'm so sorry. Can you repeat that? You cut out.
Sure. At the trial that's coming up near the end of January, what's the main issue in your mind that needs to be resolved, that needs to be sorted out?
The reason why my son refused and ran away from his father's house. I want to get down to the bottom of what's going on over at his dad's house and why he doesn't want to be there.
Okay. So the issue of parenting plan and timeframes and the like and figuring out why. Yeah. Okay. And Mr. Sorensen, what's your impression of what's to be resolved or presented at that trial?
Of changing the parenting plan that we have in place right now.
Okay. All right. Oftentimes people will come to court and they will have documents that they want the court to review and be part of the evidence that's presented. Do either of you have any documents either from financial institutions or from counselors or guardians ad litem or evaluators that you want the court to consider?
I submitted my son's counseling records. I don't know if you need to talk to his counselor or not. I'm not sure how that works.
Generally at a trial, the individuals need to be called as witnesses to testify as to what their personal knowledge is of a particular issue. So if a counselor, you want the court to know about that counselor, then you'd need to call them as a witness. If there's no objection to the records being considered from the other side, then the court can consider those records. But if they object, then you would rely upon the verbal testimony of the witness to get that information in.
Okay.
So that's something to consider, is that if you have documents that you want to have admitted, you can ask the other party. You can look under a rule, it's called Evidence Rule 904, that you can use that rule to say, hey, these are the documents I want to have considered during the trial. And you can send those documents to the other party and have them look over them. If they object, then the court will rule on it at trial. If they don't object, then they say that's okay. Then those would be admitted and considered during the trial. So that's something you might want to take a look at and file what they call an ER 904 submission or an Evidence Rule 904. And you can look that up online.
So as far as the paperwork that I have already filed, do I need to refile that as for everything that I've filed up to this point?
So declarations
for evidence.
Yeah, if you have your own declarations, you can testify and cover that information with your verbal testimony. If you have other documents that come from a third party, you may give consideration to having those submitted through the ER 904 process, or calling that individual as a witness during the trial.
Okay.
Ms. Corey, I saw you turned your camera on.
Yes, if neither party is calling me as a witness, I can strike this from my calendar.
Let me hear from the parties. Ms. Fike, Ms. Corey's indicated that you've indicated that you're not planning on calling Ms. Corey as a witness. Is that accurate?
Yeah, that's accurate.
Okay. And Mr. Sorensen, do you plan to call or potentially call Ms. Corey as a witness?
I would like to call on Miss Corey as a potential witness.
Okay, then at this point, I would like to ask for my typical fee for trial, and that is 2 hours trial prep and 1 hour trial testimony.
Okay.
That's fine. Is that an order that you could just briefly submit via email and I could sign off on it? Or is that something I could just do a bench order?
A bench order would be fine.
Okay, so let me just give myself a little note here. And that would be 2 hours prep time, 1 hour trial time. And what's the rate?
150.
Thank you. I'll prepare that order and submit that.
Thank you.
All right. So thinking about the trial, just any additional items or questions, Ms. Fike, that you have in preparation for the trial that you would like to clarify here today?
I don't think so.
Okay, Mr. Sorensen?
Other than, she's threatening to go against what a residential schedule is now. So if I was to file another contempt, it would more likely be granted outside of the trial. Is that something that could be brought into this trial, if that was the case?
So at a trial, you're welcome to raise any issue you'd like that you feel is relevant to the issues to be resolved. The court or the judge that's hearing the case may say that's okay, may say that's not okay to bring in alleged contemptuous behavior. Some people will file a separate motion based on an allegation of a contempt, and that could be heard separately from the trial. So it's not certain whether the judge would allow you to bring that evidence into the trial. She may not.
Okay, thank you.
Any other questions in preparation for the trial?
Nope.
Okay. All right. Thanks for your patience. Thanks for joining us today. We'll next see you all on January 16th at 11:30 for the readiness hearing.
Thank you.
All right. Thank you. Okay. All right. So we'll see everybody on the 15th.
Thank you.
All right. Thanks. Next, I have Tiffany Fike and Joseph Sorensen, cause number 19-3-393-08. I'll ask if Tiffany Fike is on the line.
I am. I'm here.
Okay, welcome to you, Ms. Fike. And Joseph Sorensen, are you on the line?
Yes, Your Honor.
Okay, welcome to you, sir. All right, so we're here on Mr. Sorensen's motion for a clarification regarding vacation and other, sounds like holiday events. Wanted to make sure, I didn't see proof in the file of the service of the pleading upon Ms. Fike. First off, let me touch base with Mr. Sorensen. Did you submit a declaration or affidavit of service related to that?
I did file one more.
Okay.
She had filed and did never serve me, so I just I looked it up on Odyssey.
Okay. Yep, there it is. There it is.
Yeah.
Yeah, I see it. Okay, great. Thank you. Thanks for confirming that and making mention of that. And then, Ms. Fike, did you receive a copy of those documents related to the motion for clarification?
Yes, I did.
Okay, I'll hear from you, Mr. Sorensen, then from Ms. Fike. Go ahead, Mr. Sorensen.
I'm here in hopes to establish and clarify the start and finish time for the spring break section of the holidays.
Okay.
As there is not one listed on the parenting plan. The weekend school was let out was Easter weekend, was my year for Easter with our son, and my residential weekend as well. The school flyer and the district calendar stated spring break started on Monday, April 1st, the day after Easter. And since the parenting plan did not state a begin time, it made the most sense to follow the school district calendar, as it allowed both of us to have our scheduled holiday. That seemed the most fair and logical. To confirm that, I marked it on OFW on February 14th, which would have been 46 days in advance, with a detailed start and end time. I would get Easter weekend, and she would have him from April 1st to the 7th for spring break. Ms. Fike did not object, discuss, or voice any issue, but in fact, she validated it with our son, just as I did. However, per usual, Ms. Fike argued at the last minute that evening before she emailed me demanding our son to come home the next day, disturbing our Easter weekend schedule. My objective here is to have fairness with all holidays for Ms. Fike and myself, to enjoy our son and have to avoid conflict. I'm requesting that the spring break does not include the other parent's weekend, especially if it falls on the other parent's Easter. Next year, for example, spring break will be April 7th to 11th, which lands between Ms. Fike's weekends, leaving her schedule uninterrupted, and 5 days for me to have him with spring break, which Easter falls on April 20th next year, which is Ms. Fike's already scheduled time, and it doesn't include spring break.
Okay.
So I'm asking that it basically that we adhere to the district calendar as far as spring break's concerned.
Okay. Thank you, Mr. Sorensen. Ms. Fike?
Yes, Easter is not in our parenting plan for every other year. So, and I've only gotten Christopher on Easter 2 years in the last 6. We've never had an Easter together with our whole entire family here. Spring break, this is my first year having spring break. You just put it in our parenting plan in January, and this would be my first one. School got let out March 29th, that Friday, early release at 11:50 to begin spring break. So I figured, it's my year. I should have got him from the day school got out for that early release until school resumed. That's how I figured. Like, my husband's schedule is from Friday. He gets half of spring break. So from Friday to Wednesday, and then they go to their mom's Wednesday to Friday, Wednesday to Sunday. So we got my stepkids from Friday to Wednesday, but Christopher didn't even get to come here till Monday because he wouldn't let me have him Friday. So that's why we do need clarification, because I feel it should have started Monday early release to, like the email states, to begin spring break, but I didn't get him till that Monday. But regardless, we don't have Easter in our parenting plan every other year. Last year, I got him with just my stepdaughter. Our stepboys weren't even here. So we've never had 2 years, and 2 Easters in 6 years is not a lot, because it always landed on his dad's time. That's why I wanted spring break added as well, because that was in there. I feel like I should have got Christopher on that Friday. Yeah, the district calendar says Monday through, Friday, because that's their district calendar. But everybody else is, spring break starts on the last day of school, just like every break. It starts the last day of school before that break. That's how I see it. But I didn't get him till Monday instead of Friday after school. So we only got 2 days with all of our kids together for spring break, which is not a lot. So there definitely does need to be clarification.
Okay. Thank you. All right. So it sounds like a genuine disagreement of what the court order is. And the court order, there is some vagary. It's not ironclad. It reads spring break begins and ends. Then it says day and time. There's nothing put for day and time. And then it says odd years with Joseph Sorensen, even years with Ms. Fike. So understandable why the parties had differing views on this. The way I look at it, when it says spring break, a break is a break from school. Okay, that's why we have spring break. It's generally an educationally based break. And so when you have a break from school, that means you don't go to school. So and school runs Monday through Friday. And so if you have a break from school, the break is Monday through Friday, notwithstanding kind of the expectation of like, okay, it's Friday after school. We've got this nice long weekend, and then we've got all of next week off. So I can see why one might think, okay, the Friday, the weekend attaches to the spring break. But I think going forward, just with that rationale is that, you know, an educational break is based on the educational calendar. And so when you have a break, it runs Monday through Friday. So that's how that will be interpreted going forward. So use of the school district calendar for that purpose will be used going forward in determining when spring break is. So my interpretation is that it runs Monday through Friday. So I'll just draft up just a brief order, that order of clarification that states that, and I'll file that in the court file so the parties can take a look at that. Any questions about the court's ruling?
If I may, Your Honor, is there there's a couple other that are pretty vague on, as Miss Fike has stated, that Easter is not in the parenting plan, and we have always alternated every other year, even and odd. As she stated, she had him last year, and this year was mine. Is there a way to put that in that as well, as far as Easter for even and odd?
Couple comments about that. One, Washington is a notice pleading state where if a party wants something, they have to give notice to the other side, and that notice is generally through documents and service of the same. In your motion, Mr. Sorensen, it seemed to be related to the spring break issue, controversy, if you will. And so if there's agreement between the parties, sure, I could include that in the order. If there's not agreement, then there'd have to be a separate motion, which I guess
Okay.
I think that's kind of a waste of time, but yet that's
Because
kind of
we
work
kind of
under
got
is the notice pleading and giving somebody an opportunity to know and respond.
okay, because we kind of missed the court date after our final decision. We were supposed to have one more court date that you had told us to go look over the parenting plans, and we were going to discuss if there's any fine tuning that we needed done to it, and then that court date had gotten canceled is the only reason I asked.
Okay. So yeah, so if there's agreement related to that, then the parties could certainly agree. If there's not agreement, then there need to be a particular motion brought forward to the court.
Okay.
All right. So at this point, I'll type up that order of clarification. Should have it done prior to Friday or on Friday, and then the parties can get a copy of it by checking on Odyssey or getting a copy from the clerk's office.
Okay. Thank you, Your Honor.
All right. Any questions, Ms. Fike?
Nope.
Okay, that'll conclude things. Thanks. I'll ask if Ms. Fike is on the line.
Yes, I'm here.
Okay, welcome to you, Ms. Fike. And Joseph Sorensen, are you on the line?
Yes, I'm here, Your Honor.
Okay, welcome to you, Mr. Sorensen. We're here on a motion brought by Ms. Fike regarding the lifting of a restriction as it pertains to her mother, Jill Hall, who's the grandmother to the children, her child. This stems from a November 17th, 2020 order issued by Judge Basher, which indicates that Ms. Hall was prohibited from having contact with the child, and that she could have contact with the child if several things happened. One was that she involved herself and completed a state certified SUD, substance use disorder treatment program, and that she provide clean hair follicle tests. And it is a plural word, test. So it's tests. So I reviewed the clean hair follicle test that was showing no substances from June of 2023 from Ms. Hall. So I'll hear from Ms. Fike and then Mr. Sorensen. Ms. Fike?
Yes, as you were stating, Judge Basher ordered a no in-person contact between my son and my mother due to hearsay from others accusing my mother of drug use 3.5 years ago during my custody case. The respondent has said that I was one of those accusers when in fact I was not. I have never said that. I apologize. I've written declarations against Rhonda Larson's report stating different things that I have never said that were in her report, including her saying that I didn't want my son to have contact with my mother. There's no reason for me to bring my mother into my custody case. If I suspected anything, then I would have stopped their contact on my own. I wouldn't have needed the courts to do that. The respondent states that Jill Hall has been absent from our son's life since 2020, but that's not the case either. When Christopher is home, he talks to his grandma often through text, phone calls, and even FaceTime. because the restriction was only for in-person contact. The only contact they haven't had is in person. To say our son doesn't want to see his grandma is 100% false. Christopher asks me regularly, when does he get to see his grandma, that he misses her so much. And Christopher told me the other day that he talked to his dad about it. Then all his dad said was, that's up to your grandma. For the respondent to say that he believes I filed the motion to create a continued court conflict is appalling. I filed this motion so my son can be reunited in person with his grandmother. I filed her hair follicle results last year. I was told by the clerks that all I need to do was file the results and to bring it up in my next court date, which I have more than once, and it was ignored. The text messages between my mother and my son were already brought up and dealt with, and those are over a year old. She has not talked to my son about anything in over a year. My mother's influence in our son's life has only harmed the respondent's relationship because he has never liked my mother. My mother's test results would have been current if it was paid attention to when I filed it the first time. Her license and her car insurance were already provided to the
Can I
court.
ask you a question, Ms. Fike?
Yes,
You said that the test results from June of 2023 were previously filed. Is that correct?
yes.
Okay. Was it filed?
Maybe in September, maybe a few months after she gave it to me, because I wasn't sure how to file. And then I went to the clerk's office and tried to file this same motion, and they said, this is how you do it. We'll just submit the results and you just bring it up in your next court case. So that's what I've been doing, and it's obviously was been wrong. So now I filed this motion again.
You're saying you filed this a second time?
This is the second time I filed my mother's test results. Yes, under seal.
As far as a motion though, was there any prior motion related to?
No,
the
because
motion?
I went to do the motion and the clerks told me that it wasn't the right way, and to just submit, since I already had a court case going, to just submit those results into court and then bring it up in my next court case.
Okay. All right. Thank
And
you.
I explained to them I needed a motion, and they said, no, just do the test results. So that's what I did.
Okay.
They haven't seen each other in 3.5 years, but they've FaceTime, they've talked, they've had communication. It's not like they have not seen each other in almost 4 years. But he's devastated and would really like to see his grandmother.
Okay. Thank you, Ms. Fike. Mr. Sorensen?
Since she declined a drug test, Jill has been away from our son's life for over 4 years by choice. Our previous GAL and Judge Gary Batcher found that her likely drug usage and parent alienation of Tiffany and myself were both issues, so they ordered no contact and requested drug testing. Mine and Tiffany's comments to the courts and GAL that her mother's involvement into our son's upbringing by both of us are documented. The text between our son and Jill Hall that I have filed show she includes him in adult and court affairs, lies to our son, name calls his stepmom, blames my wife for her drug test, terrifies, guilts him, interrogates him, and talks negatively to him a lot of the schedule with myself. My goal is to provide our son with healthy influences, especially from family. Since the January custody transfer to myself, our son is healthier than ever, and I ask the courts to safeguard that. Reuniting our son with Jill should be a process. Our son is now 15 and a half and was a child when last saw Jill. I support whatever healthy efforts Jill takes to be a positive influence in our son's life. I love our son more than any dislike I have for Tiffany or her mother, Jill. Tiffany submits a drug test allegedly taken by Jill nearly 10 months ago, not a current one. Tiffany has been petitioning for her mother in court to see our son, not Jill herself. I'm asking the courts to see that. Jill Hall's drug screen to be current and taken on site, that the courts verify results and institution. If granted, our visitation should come with restrictions to avoid further alienation and disparagement of any kind. Our son is doing well in school and mentally. I'm nervous about any disruptions that can throw his success off. Introducing Jill back into his life abruptly with no restrictions or proof of a current class test is risky.
All right. Thank you, Mr. Sorensen. All right. So I think the key is to look at the November 17, 2020 order, which says that there's to be no in-person contact with Jill Hall and the child. And then the judge has indicated that there can be contact if there's completion of a state certified SUD treatment program, and that Ms. Hall provide clean hair follicle tests. So number one, there's some at least kind of in the back of my mind, there's some concern that it's been 3.5 years and there was a hair follicle test that was given in 2023. I don't have any proof of any SUD treatment completion. So one of the preconditions or conditions for any type of visitation indicates that there's not been an SUD treatment program that's been completed. So by that term and that term alone, then there would be a denial of the lifting of the restriction for the visitation for grandma. Secondly, that the court order from November 2020 indicated that there needs to be provide clean hair follicle tests, and it's using the plural tests, it's not singular. So therefore, we have one clean hair follicle test from June of 2023. If there were to be a second one, a more current one, then that could be addressed in conjunction with proof of completion of the SUD treatment. So those are the preconditions that are antecedent conditions that need to be fulfilled before a motion would be properly entertained. So at this point, I'm going to deny the motion to lift any
Can I
restrictions.
ask a
So the
question?
November 2020 order still remains. You may.
Okay, I haven't talked to her about the state certified treatment in a couple years, but she told me back then that there's no reason to go to, the treatment if she's not on drugs. So she has that clean hair follicle test. So what if she goes to go into treatment, but she's clean? Do they still do a treatment? Or will they just sign off right then saying that she's clean and she doesn't need treatment? So how does that work since she's already taken a clean hair follicle test? I'm just confused on that.
So the court's decision, let me just pull it up here again. Says any in-person contact between the child and the grandmother needs to stop until such time as the grandmother can provide proof of completion of a state certified SUD treatment program and provide clean hair follicle tests. Upon completion of those requirements, the court would entertain a motion to lift that restriction. So generally, before any type of treatment occurs for SUD, there needs to be an evaluation. If the evaluation recommends treatment, then that treatment program would need to be completed. If there's an evaluation and it recommends that there be no treatment, then that ends the inquiry at that point, that there's no further requirement. And so there we go.
Okay,
So,
thank you.
so I will prepare a short order that's denying the motion. I'll have that filed. And any questions from you, Mr. Sorensen?
No, Your Honor.
All right, that'll conclude today's hearing. Thank you.